Right, let me get myself involved in the ongoing argument about Nigerian constitution as to whether Tinubu actually won the required number of votes in in Abuja. Well, I must say that I am not advocating for any particular candidate. Nobody has instructed me or anything to speak on their behalf or anything. I'm just going to be as objective as I can, and this is going to be for mainly educational purposes. It's not to be used by anyone for legal advice. I like to get myself involved in some of these challenging topics. It's very interesting as I see it to get involved in this academic argument. I call it academic because it doesn't matter what I say here. What matters is what is decided in court, and whatever that outcome is nothing to do with what I've got to say at all. And is actually my view. I am going to act almost as a tutor here, and for educational purposes. So I will look at the problem of the 25% rule as I see it, and I'm going to be very quick about this. My understanding of the 25% rule is that each of the candidates must score 25% in each of 2/3 of the 36 states of the Federation and the Federal Republic of and Federal Capital Territory Abuja. The problem which I have seen that Nigerian lawyers and the judges are grappling with, have tried to grapple with, is the "and," which a lot of them say that it is conjunctive, meaning that someone has to win 25% in Abuja before they can be declared the president of Nigeria. It is interesting. The reason why I decided to look into this is that obviously, if someone has to win 25% in Abuja, even though the person has won elsewhere, but hasn't won 25% in Abuja, and then the person doesn't become Nigerian president for that reason because of one city or because of one state, then it appears to me that that one state or one entity of the whole federation is given the veto power to overrule the majority of Nigerians. To this end, then most lawyers will see this as a mischief, or will see this as something that was not intended by the Constitution. So I think the problem here is that the Constitution has been interpreted and over-interpreted, and it's been read too much. One thing about legislation is that you don't read it too much. Once you've read it, you should understand it. Bearing in mind that the law is not designed for lawyers. The law is designed for the fish seller, the person that sells bread on the street. That is the person that the law is designed for. The law is not designed for the lawyers. They're not designed for excessive interpretations, and they're not even designed to go to the Supreme Court. They are designed to be understood by all ordinary people. You don't have to be a lawyer to understand the law. That's the reason why anybody can go to prison. They cannot say they don't know the law, because you don't have to know the law. You just need to know what is right and what is wrong. So, and this is the basis of understanding the intention of those that drafted the statutes. So, when you want to understand the meaning of a particular word in any statutory document, the first thing that you should understand is the intention of the drafters. Not the intention of the drafters, but the intention of the lawmakers. That is what you need to understand. Sometimes the legislation itself, in this case, the constitution will provide some kind of guidance. So lawyers will need to look for guidance to the interpretation of that rule within that constitution itself. Say, for example, I'll take you to section 2.2 of the Nigerian constitution, which is, if you look at section 2.2 of the Nigerian constitution, it says, Nigeria shall be a federation consisting of states and a federal capital territory. So this section 2.2 has provided the guidance to understanding the words used under section 134, which is the problem at the moment. Because the problem a lot of Nigerian lawyers and judges are grappling with is the meaning of he has to win 25% in at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. So if you look at here, it says 2/3 of all the states of the Federation. Stop here. So you just stop here and you go back to section 2. And you will see where it says section 2.2, Nigeria shall be a federation consisting of states and federal capital territory. So once the section 2.2 has defined Nigeria as a federation, and it has now defined Nigeria as a federation consisting of states and federal capital territory, under section 134, it's no longer necessary for the addition of the federal capital territory. So that is a drafting error. So that should not, those that were drafting this constitution should not have added and federal capital territory at section 1341B. So this is what section 1341B should have read, that he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the federation. There is no need to add and the federal capital territory. That is the problem that the judges are having at this moment in time. And unless that drafting error is corrected, this error will continue, this problem will continue. It cannot be resolved by way of interpretation. Now, the judges, the judges, which is the courts, the judiciary has the power to correct obvious drafting errors. They do have the power to correct obvious drafting errors. Once the drafting is not in consonance with the intention of the whole document, then the judiciary is entitled to interpret the provision by omitting and the Federal Capital Territory Abuja. That and the Federal Capital Territory Abuja under section 1341B should not have been added. Because the reason why I say it should not have been added, which I'm going to repeat here, is because under section 212, it has already made the definition and given the guidance as to what the federation is. It has already said that the Nigeria shall be a federation consisting of states and a federal capital territory. So, now under section 1341B, he has said, then they said he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the federation. There is no need to mention and the Federal Capital Territory, Abuja. But having mentioned the states here, one can say that having mentioned the states in the federation, it was also necessary to mention the Federal Capital Territory. So, the states should have also been omitted. But the fact that it has mentioned the states, so it also needs to mention the Federal Capital Territory, Abuja. Now, and this is the reason why when it is interpreted to mean that you must win Abuja, which is basically, when you read this document, that's what it says. This document says you must, if you win the whole states and you haven't won Abuja, for example, and if you haven't got 25% in Abuja, then you don't win the election. But that cannot have been intended by the law, given the fact that under Section 212, it had described the Nigeria as a federation consisting of states and the federal capital. And then it should not be duplicating that again, using the federation, states, and the federal capital all together here. Should have omitted the federation. So the use of federation here under Section 134(1) means is the confusion. So is it that the federation was used and neither states or Abuja was mentioned, or the states were mentioned and Abuja mentioned, but the federation not mentioned? So this is the reason why I consider that Section 134(1)(b) was a pure drafting error, and it cannot be resolved. The only way it can be resolved is for the judiciary to take a stand on this and come to, which is possibly the Supreme Court, and come to a conclusion as to what the provision should be, and then they now interpret it to read what the intention under Section 222 has given guidance to. There is a Supreme Court case law. There was one senior advocate of Nigeria that mentioned that law, which was a Supreme Court judgment in 2008, where the Supreme Court has already concluded that one has to win Abuja, otherwise they haven't won the election. And that decision stands as it is. In my view, obviously, in my view, it will be wrong. But the Supreme Court has made that decision. It should stand. And what that is having the Supreme Court having made that decision, which in my view is wrong, and in the view of most Nigerians, that may also be wrong. What should have happened following that decision was for the legislative arm of the government to go straight to amend the Constitution, which is Section 134(1)(b), either to overrule the Supreme Court or to confirm the ruling of the Supreme Court. That's what they should have done. The Senate and House of Reps, they should have done that since 2008 to come to a final position as to what it should be. And this Section 134(1)(b) should have been amended all along since 2008. Having not amended it, and it's too soon, it's too late now to be amending it for this case. The judiciary will have no option than to follow what was decided by the Supreme Court in 2008. That it means that Abuja must be won before declaration of the winner, before the person who is declared the winner must win Abuja before the person is declared the winner. In this case, Tinubu, they said he did not win the requisite number of votes in Abuja to be declared the winner. And when I started this, one of the things that I first said here was that I referred to Section 134, again, Section 134(1), where it says a candidate for an election to the office of president shall be deemed to have been duly elected, where there being only two candidates for the election. Now, in this election, there were more than two candidates. So that brings into question whether Section 134 is applicable at all. Does Section 134 help anybody? Does this Section 134 assist Obi in a case where there are more than four presidential candidates? because Section 134 says it is only applicable, 25% is only applicable where there is 2 candidates only. And then another thing I have to quickly chip in here is that there is another, obviously a lot of people have seen this as a smoking gun to nail Ahmed Tinubu or so, but it is not a smoking gun at all. It is difficult. Basically, when you look at the other provisions of the Constitution, it says, which is the requirement for runoff. I haven't got those provisions here with me, but if there is any debate or any opposition as to whether someone should have been declared the winner of the presidential election, then the INEC has to conduct a runoff, and the runoff has to be between between 2 people only. Has to be between 2 candidates, and those 2 candidates will be the 2 candidates that scored the most votes. So what should be important to all the candidates in this very case now, which is the court case that they have at the moment, what should be foremost in their minds is to prove that they scored the highest number of votes, because it's only the 2 candidates that scored the highest number of votes that will take part in any runoff election, and that takes precedence. That issue it takes precedence over the issue of 25%, and a lot of people have been asking why is it something that is so obvious that Tinubu has not scored 25%, and there is a Supreme Court judgment in 2008 that provides that ruling. Why is it that that issue has not been resolved yet? No, because to resolve that issue, the court will need to first of all, that's assuming I am wrong, that this provision only applies in a case where there are only 2 presidential candidates. So, but in order to resolve that issue, the tribunal will have to be satisfied that will be satisfied that certain number of candidates scored a certain number of votes. So they have to first of all establish the number of votes validly scored by each of the presidential candidates, because they have to know what decision they're likely to make, and if they're ruling a runoff, is that going to be between who and who? And that issue will have to be determined before they can go and talk about the issue of 25%. So I think this video has gone on longer than I expected. I can go on for more and more and more, but one other thing, a section that I also need to mention here is section 299. Section 299 of the Constitution says that the provisions of this Constitution shall apply to the Federal Capital Territory, Abuja, as if it were one of the states of the Federation. So if you look at section 299, it looks as if it does not make any distinction in terms of whether Abuja is a state or a federal capital territory. So again, that also has to be taken into account when deciding whether Abuja, whether someone must win 25% in Abuja. Now, in conclusion, in my view, I do not think that it is the intention of the constitution makers that Abuja should hold the veto power to overrule the entire nation in deciding who should become the Nigerian president. Second point that I'm making in conclusion is that Section 1341, about two-thirds of the states and Federal Capital Territory of Abuja, the way it was drafted is a drafting error, which should not have been drafted that way. And then I have said that the judiciary, which is the Supreme Court, have the power to correct that wrong drafting. And after this, the legislative arm of the government, which is we shouldn't be back here again. The Senate and the House of Reps, is it House of Reps they're called? Yes. The Senate and the House of Reps, the National Assembly or as a whole, should make sure that Section 1341B is reviewed and amended accordingly. It should not continue to sit there, otherwise it will continue to pose problems. In regards to decision, I'm not sure, but I have heard this from a son that there is a Supreme Court judgment 2008 that makes it compulsory that one interprets this, that one must win Abuja. Now, that obviously that is the law. But anyway, before the Court of Appeal, which is the election tribunal, can get to that point, they will have to first of all determine who has the most votes and who comes next, and then make a decision as to whether they're going to order a runoff. And if they're going to order a runoff, on what basis? Will it be on the basis that someone hasn't scored 25% that is necessary to be declared the president-elect? If that is the case, they will follow exactly what ruling the Supreme Court made in 2008. They will follow what ruling the Supreme Court made in 2008. But as to do that, they will also give permission straight away to any party aggrieved to go to the Supreme Court to get that confirmed, to see whether the Supreme Court will be able to review their 2008 decision. I don't think that is likely, because whichever way this Section 134 is interpreted is going to still cause a problem, unless the Supreme Court will have to come to a view this time round and say that they were wrong in 2008, that they are now reviewing it, and they believe that Section 134 was drafted incorrectly, and this is what it was intended. Then they will now refer to Section 222, that Nigeria shall be a federation consisting of states and the Federal Capital Territory. When you read Section 22 together with Section 299, then it will tell you straight away that the intention of the constitution drafters was that Abuja and states should be treated the same. That the states and Abuja should be treated the same. So 25% should be 25% of all the states in the federation, including Abuja. Thank you very much.